Adam Bailey, Austin Davis, Aaron Freeman, Joshua Harris, Robert Hill.
All right, Adam Bailey.
No, sir, Josh.
Mr. Bailey. All right, this is State of Ohio versus Adam Bailey, CRB 21-859 A and B, CRB 2304, CRB 143740 A through D, CRB 12528 A, B, and C, CRB 12480, CRA 121016 A, and CRB 121070. On the CRB 21 case, looks like you have paid a grand total of $15. On the CRB 20 case, nothing. On the TRD 143740 A through D, you've paid $60 since 2014, but you did do your community service. It's like since we were last here, you've done 6 hours. On the CRB 12528 A, B, and C, nothing. On the CRB 12480, paid a total of $50. You're seeing more community service, and on the CR 812 and CRB 1017, $20. All right. Mr. Bailey, you're going to have to start doing a little bit more.
Yeah, I just completed my parole down at Ironton. Got everything paid off. I talked to Capper last time about it. I just started Saturday community service, so I'm going to be doing Saturdays because I work through the week. But I got all that finished, so it's time to. I asked Mr. Cooper to tally up my hours Saturday, and he did, so I'll start nipping at that.
Okay. I'm going to set you back for a review on September 18th.
Is that a Friday?
It is a Friday.
Thank you. September 18th.
Yeah, review at 9 a.m.
All right, thanks.
All right, thank you. Austin Davis. All right, this is State of Ohio versus Austin Davis, TRC 25-1966. And Mr. Davis, you've done nothing.
I'm going to pay all my fines today.
Okay, how much are you paying today?
It's whatever it is.
$595?
Yeah.
Okay, so you're going to pay it in full today?
Yes.
All right, I'm making a note that you're paying it in full today. I'm going to set you a review for September 18th. Once that is paid in full, that will be vacated, so you won't have to close the case. However, if you do not pay that in full and it's not taken care of on September 18th, not going to be real happy because you tell me you're going to take
Oh,
care
it'll
of
be
it.
paid today.
Okay. All right, so I'll see you back September 18th. Hopefully you paid it off, and then I don't have to see you back September 18th.
All right.
All right,
Thanks.
thank you. Aaron Freeman.
Right here.
And this is State of Ohio versus Aaron Freeman, CRB 25-318, CRB 25-174. And looks like we made a $30 payment today.
It was yesterday. I have a
Or,
question.
excuse me, yesterday.
I have my receipts. I didn't know if I could. I'll show you.
Show them to Cooper here.
It went. I didn't understand the grand total, how it changed.
Is Aaron Freeman? I need his case numbers, please.
CRB 25174 and CRB 25380.
There was a warrant. It's a warrant fee of $100. It was put on May 29th. That may be the question, the answer.
Take this back to him. Warrant fees
Okay.
from where you miss court. Miss court, when we issue a warrant, there's a fee that goes with that.
Yeah, it was last time I was here. I didn't know that. I'm sorry.
Okay. All right, I'm gonna set you a new review. I'm gonna set you back on September 25th,
So what day is that?
Friday,
Friday.
at 9 a.m.
Thank you.
Thank you. Joshua Harris?
Yes, sir.
All right, this is State of Ohio versus Joshua Harris. CRB 25748, CRB 21289, CRB 290, and CRB 21999 A and B. Harris, I'm not seeing you've done anything on any of these cases.
I just did the 30 days in February, and then February, I had to do 30 days. Then I got out, and in May, I brought my paperwork if you wanted to see it, and some pictures for you. I ended up having some type of episode where I was in a coma. I woke up 7 days later in the hospital, and I was on a ventilator for 6 days. And I've been out of the hospital for 2.5 months now, and I'm back working, and I plan on making a payment on everything August the 15th.
Okay.
You want to see my withdrawal or the release papers from the hospital or anything?
I'm gonna set you back, you're here. I'm gonna set you back for September 18th for review. And on both that we're gonna need some substantial progress on this.
Okay.
So
September
that's not-
what?
September 18th at 9 a.m. That's Friday. That's not a 1 day of community service or a.
That's another thing I was wanting to ask you. What can I do about I heard I can do community service to also pay off fines?
You can speak with Mr. Cooper about that.
Okay. At 9 a.m., right?
Yes, sir.
Thank you. Have a good day.
Thank you, too. And Robert Hill. So State of Ohio versus Robert Hill, CRB 2624 A and B, CRB 24335. Mr. Hill has failed to appear. I'll be eventual issue.
Chase Holdren, Randy Jackson, Bertha Reaming, Angela Spurlock, Joshua Turner.
Chase Holdren. All right, this is State of Ohio, Chase Holdren, CRB 25772. All right, that's a good report, Mr. Holdren. Set you back September 18th for review at 9 a.m. Ms. Jackson, the State of Ohio versus Randy Jackson, PRC 252359 A and B. And Ms. Jackson, you are the star of the day. You have done 52 hours of community service since your last hearing, and you're just down, it looks like, the $449 left. So you're making good progress on getting this resolved. Because you've done so well, I'm not going to set you back so far. So I'm going to set you back October 30th for review at 9 a.m. And with any good fortune, if you keep up your pace, that'll be paid off before you need to appear, and that'll be vacated.
Yes, sir. Thank you.
Thank you, Ms. Jackson. Bertha Remy. Okay, it's the State of Ohio versus Bertha Remy, CRB 26-233 AMB. And I was given a report, Ms. Remy, and it looks like you're continuing to test positive for THC, and not only are you testing positive, but your levels continue to go up.
Your Honor, Ms. Remy's not here.
So she just didn't hear.
Yes, she needs to go into residential. She is not open to the idea of change. I know she's got some things going on, but we've had screens of positive oxycodone, hydrocodone. I didn't know I was supposed to be there. Oh, I don't have a car. She just needs to go in.
Well, there's an easy way to accomplish that. She has not appeared here today. So I'm going to issue a bench warrant for failure to appear. If you hear from her and she comes in, I will then take up the issue at that point, but I would anticipate that is not a good report, and we will handle that issue when we have a report.
Thank you, Your Honor.
All right, thank you. Angela Spurlock.
Yes, sir.
This is State of Ohio versus Angela Spurlock, CRB 18-1327, CRB 18-1297, and CRB 18-558. All right, you're making some progress, Ms. Spurlock.
Well, I'll have my community service done by next court date, for sure.
So I'm going to set you back for review on September 25th.
9 a.m., correct?
9 a.m., correct.
Thank you, Your Honor.
Thank you. Joshua Turner, the State of Ohio versus Joshua Turner, PRC 25625 AMC.
Your Honor, Mr. Turner's done well. He's graduating from the residential program, and he's secured a very good job. He's reincorporating with his family. We're going to work with him on an outpatient basis just due to history and the environmental change.
Your Honor, if I may, he was ordered to do some community service on his last hearing, and he has turned in 21 hours this morning.
Okay. Well, that's by all accounts, that's excellent reporting, Mr. Turner. I'm happy that you're graduating. I'm happy that you've got a good job. You do have a substantial amount of community service left and a pretty high amount of time left, but getting working should be able to help with both of those. So you've done so well that I'm going to give you a little bit more time before we come back before the court. I'm going to set you back on October the 30th. And that'll be a review at 9 a.m.
You mean to? Thank you, Your Honor.
Thank you.
Thank you.
We're ready for arraignments, Your Honor.
All right, the next group of cases we're going to call are some arraignments that are ready. If you have an arraignment, I need you in the courtroom.
Arraignment.
All right, when you hear your name called, come down to the table on my left, your right, and we will go through your charge or charges with you. If it is a misdemeanor offense, you can enter one of 3 pleas: guilty, not guilty, or no contest. If you enter a guilty plea, you're making a complete admission that you committed the offense charged. If you enter a not guilty plea, you are denying that you committed the offense charged. And if you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding the offense. And then if I think the state would otherwise have enough evidence, I can enter a guilty finding. You have the following rights before the court. You have the right to remain silent. Everything we're doing in here today is being recorded. So if you start telling me about your case, you may say something that you shouldn't say. And Mr. Keel, that is walking in the courtroom in the state of Ohio, can get a copy of that and potentially use it against you later at a trial. You have the right to have an attorney. If you do not have the money to employ an attorney, I can appoint one to you at no cost if you meet the criteria for that. You have the right to have reasonable bond set in the matter. You have the right to force the state of Ohio to prove each and every element of the offense is charged beyond a reasonable doubt. We'll go ahead and call the first resident.
State of Ohio versus Cameron Lambert, CRP 26417, A, B, and C.
All right, this is State of Ohio versus Cameron Lambert, CRP 26417, A, B, and C. Sir, you're Mr. Lambert?
Yes, sir.
All right. On the A case, Mr. Lambert, it's alleged that on or about June 22nd, 2026, you did with purpose to deprive Lowe's, owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise, without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913.0281. That is theft. That's a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 180 days in jail and up to a $1,000 fine. On the B case, it's alleged on or about June 30th, 2026, you did with purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise without the consent of the owner or person authorized to give consent. Also an alleged violation of Ohio Revised Code Section 2913.0281, theft. That's a misdemeanor of the first degree. Maximum penalty on that's up to 180 days in jail and a $1,000 fine. On the C case, it's alleged on or about June 21st, 2026, you did with purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise, without the consent of the owner or person authorized to give consent. Also a violation of Section 2913.0281, theft, misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and $1,000 fine. Do you understand the charges that I just read to you?
I do.
And do you understand your rights before the court?
I do.
How do you wish to plead?
Not guilty.
Okay, I'll accept your not guilty plea. Do you have money to hire an attorney?
I do not.
All right. Are you working presently?
I am.
All right. Are you paid hourly?
I am.
All right. How many hours a week do you get?
It varies. I just started the job. Only work 2 to 3 days a week right now.
Okay. How many hours would you say? So about 25 hours a week?
Probably 20 or so, yeah.
Okay. How much you paid per hour?
$15.50.
All right. You're going to qualify for appointed counsel. I'll appoint Attorney Roger Smith to represent you. Mr. Hill, do you want to be heard on bond?
Your Honor, we're not opposed to no our bond.
All right, and I'm going to have to order Mr. Lambert's going to have to get fingerprinted at the Lawrence County Jail, so he can go to do that.
I received a summons in the mail. And don't leave, I'll bring a copy of this to you.
Mr. Smith, how soon do you want to come back?
What's the date you're setting, Judge? I've got August availability.
Looks like the August 21st and or 24th start the better days. Prior to that, they're pretty booked up.
Okay, the 21st is better for me. That's a Friday.
Yep.
Is that a good day for you, August 21st? Okay, my client's going to double check his calendar.
Yeah, August 21st.
August 20th, it's a Friday. It's 3 weeks out from today.
That should be fine.
Okay. I don't want you to.
All right, I'm going to set it back for August 21st for pre-trial at 10 a.m.
Your Honor, if I may.
It's going to be a $2,500 award.
Tell me just a point. I got it here earlier. You just set an appointment with them before the 21st. And bring that with you.
Don't give this to you.
Not there yet, because if we're going to talk about any of the stuff you need, then you're free to go.
Okay.
State of Ohio recalls Bertha Remy, case number CRB 26233, A and B.
All right, this is State of Ohio versus Bertha Remy, CRB 26233, A and B. This matter was set for review hearing, and Ms. Remy wasn't here, even though she was here at 9 a.m. There was a warrant issued, but I indicated that if she appeared, I would call that warrant, so I'll go ahead and note for the record that the warrant's recalled. Ms. Remy, I'm going to recap kind of what was said on the record here. I received a report here, and it is not a good report. And I will read to you exactly what was listed in the report here. Bertha continues to test positive for cannabis, indicating ongoing challenges with abstinences and the need to continue support and strengthening recovery-oriented behaviors. Though there is progress with her THC levels, they continue to raise, and there have been growing concerns over opiate use. And the treatment provider believes it is in your best interest for you to be placed inpatient. Taylor, anything that you wish to add to that? I know that there were some things that you had indicated for the record earlier.
After a meeting with her clinician, there's been some resistance about issues that are prevalent. And I mean, you can use what you want, but your THC levels are going from like 600 to 1,000. And then there's a hydrocodone and oxycodone positive in there a couple weeks back. It's just, we feel it's in her best interest to go into residential.
All right, Ms. Remy, I'll give you an opportunity to speak before I...
Yeah, Mr. Capper, the first couple weeks was messed up. I had a tooth break off. That's why the pain medicine was there. I've not had any since then. The THC level, I'm waiting on a neurologist, which I have stopped. I mean, I don't know why the levels have even, like, I don't drive, so, I mean, that's, I have done, like, we've moved to Pike County, and I have put everything, there's no one that'll try harder. Like, I have really cleaned myself up. And, yeah, the THC has been a problem because it's been 20 years for medical use. I had epilepsy. So, but there, I mean, there's no one that's trying harder.
And it's not that we don't believe that she's trying, it's that she doesn't have the skills that are necessary to maintain it.
But I have a different support system, and we're working on changing everything. I was kicked out of my home I lived in for 20 years, so there was depression issues on top of that. You know, my dad told me he didn't want me no more, so, you know, therefore there was that. But I've changed my life around. It's been a whole life change, and even in outpatient, they're helping me, like,
Well, I'll tell you, Ms. Remy, here's how I approach these cases. I don't practice medicine. I don't
Right.
practice psychology, any of those things. Hang on, let me speak. I have to rely on the people that do those things in order to know what you need. I don't know you. I don't know
Right.
your personal background. I know what little history that you've given me and what's in the report, but the reports going back have all said kind of the same things. And I have to rely on the providers to tell me what it is you need. And so they're telling me that you need inpatient treatment.
I have a doctor's appointment on the 27th with Erica Schuster. She tried to get me to come when my mom passed, and I didn't. I should have listened. I have a long
Seems to be
time.
a lot of that going on.
Right, I have a long-term fear of doctors. So,
Well, I'm going to go ahead and stop you at this point. I'm sure that Bethesda will get you to that doctor's appointment if that is an appointment, but at this point, you're either going to have to go inpatient treatment or we're going to have to go another route that does not include treatment. And that other route likely lands you in Lawrence County Jail. So those are your two options. Do you prefer the treatment or do you prefer jail?
You're gonna get passes and stuff like that. You've got trauma, you've got a ton of things going on that need to be addressed in order for you to have that life.
I've just been given the first chance in my life to buy my own property. And that's why Judge Capper was working with me a little bit.
And Judge Capper left a note that basically is that we better have a compliant report today. And
I thought I was complying. They said my levels was going down. I talked to the mental health counselor yesterday, and she said my levels were going down.
They spike and then they went back down. So that's what that means. So there's use and then it comes back down. So I'm not here to justify what you're doing.
Right.
The lab is the lab.
Right, but I don't understand that
I've already
stuff.
told you, I don't need to hear anything else. I just need to hear whether you're willing to do the treatment or whether we need to go another route. Because if you don't want to do it, then I don't have much by way of option. I mean, you got to do what's been ordered, and you were ordered as part of this. As part of your probation to do what's required by your treatment provider. And your treatment provider is saying you need inpatient treatment because you're not compliant.
I'm sorry for the pause. I'm shocked because like I said, I don't apologize for my pause because this is not an easy decision.
It is, you get a better life.
My life was turned around when I was taken out of the position that I was in that caused the issue of me being.
Well, here's what we're going to do right now. I'm going to go ahead and remain her into custody at this point. She can think about it in the back. We'll have you out later in the docket.
Thank you, Your Honor.
We'll have plenty of time to think.
State of Ohio versus David Woodard Jr., case number CRB 23754, CRB 2145, A, B, and C, CRB 19738.
All right, this is State of Ohio versus David Woodard Jr., Series 23754, Series 2145, A, B, and C, Series 19738. And it looks like Mr. Woodard failed to appear for review. Some time ago. Mr. Woodard, do you admit or deny that you failed to appear for your review?
Admit.
Okay. And do you have a good reason as to why?
No, I don't.
How long have you been in treatment with RRS?
July the 17th.
Okay. And did he come in on his own?
Yes, sir.
Well, that's a good start, Mr. Woodyard. So here's what I'll do. I will recall any outstanding warrants out of this court, mainly because you checked yourself into treatment. I am going to set you back for another review hearing, and I'm going to order that you remain in that treatment as part of your sanction for not appearing. And I'm going to set you back for another review on August 31st. That'll be a review at 9 a.m. And you're ordered to continue treatment with RRS.
Thank you, Your Honor.
Thank you.
State of Ohio versus Adam Bates, case number CRB 26466.
All right, this is State of Ohio versus Adam Bates, CRB 26466.
Yes, sir.
All right, Mr. Bates is alleged on or about July 28, 2026, you did purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 29130281. Theft, that's a misdemeanor in the first degree. Misdemeanors in the first degree carry a maximum penalty of up to 180 days in jail and up to a $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. Do you have money to hire an attorney?
No, sir.
Are you working?
No, sir.
All right, so you have no income?
No.
All right, I'll appoint Attorney Sean Stratton to represent you. I'm going to continue the current bond. He's already posted a bond with Mr. Sowers. Mr. Stratton, when would you like to come back?
It's up to the court.
Fridays are best for you? Is that correct?
Any day, but the 17th and 24th of this month are not good.
Okay, so we'll do the 21st.
21st, okay.
That'll be a pre-trial at 10 a.m. And he'll need to go to the jail to get, were you booked into the jail?
Yeah.
Okay.
So he should already have fingerprints.
Okay. All right, I'll see you back, Mr. Bates, August 21st at 10 a.m.
All right, thank you.
State of Ohio versus Shannon Brunson, case number CRB 26468. Shannon Brunson.
All right, this is State of Ohio versus Shannon Brunson, CRB 26468. Ms. Brunson, it's alleged that on or about July 29th, 2026, you did purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services to give miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913.0281. Theft, that's a misdemeanor in the first degree. Carries a maximum penalty of up to 180 days in jail and up to a $500 fine. How do you wish to plead?
Guilty.
You want to enter a guilty plea?
Guilty.
Do you want to make a complete admission that you committed the offense charged? No, I see you
Yes.
nodding, but okay. All right, I'll accept your guilty plea and enter a guilty finding. Prior to us doing sentencing, I'd like to have her here on screen. So we'll have you back out here shortly to do something.
Okay, well, okay.
State of Ohio versus Emily Lockwood, case number CRB 26467.
Are you Emily Lockwood?
Yes.
All right, this is State of Ohio versus Emily Lockwood, CRB 26467. Ms. Lockwood, it's alleged that on or about July 29th, 2026, you did purpose to deprive Walmart, owner of property or services, knowingly obtain or exert control over said property or services to wit miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 291302A1. Theft, that's a misdemeanor of the first degree. Maximum penalty on that goes up to a $1,000 fine and up to 180 days in jail. How do you wish to plead?
Not guilty, Your Honor.
Except you're not guilty, plead. Do you have money to hire an attorney? Are you working?
Not right now.
All right. So what I'll do is I'll appoint Attorney Roger Smith to represent you. Looks like there was a medical OR bond, so I'm going to go ahead and issue a $2,500 OR bond in lieu of the medical OR bond. And she's already been fingerprinted. And Mr. Smith, I already know you're here August 21st. So
Yeah, that's a good day, Judge.
I'm going to set you back August 21st at 10 a.m. for a pre-trial, Ms. Lockwood.
What's the date, Your Honor?
August 21st. Apparently, there was something in the water on July 29th, because every charge we had was a death charge from that date.
Thank you, Judge.
Thank you.
State of Ohio versus Chance New. Pre-trial, Your Honor, case number TRC 25-24.
This is State of Ohio versus Chance New, TRC 25-3024 A and B. Mr. Haslam's case set for pre-trial, and Mr. New is present here today.
Your Honor, if I may, Mr. New was ordered to do 60 hours of community service before sentencing. He completed all 60 hours of community service.
Thank you, Mr. Cooper.
Your Honor, in addition to the community service, Mr. New has also completed an AOD assessment, which I believe had been provided to the court, recommended that he did not need any services. In addition, we also have the certificate of completion for Mr. New's driver's intervention program. If the court would like to see that, that's Mr. New's copy. Mr. Heald has already seen it. So at this point, Your Honor, I would ask that we proceed forward to sentencing and the plea, I guess officially. So the agreement reached with the state is that Mr. New will plead guilty to the speeding charge. The OVI will be amended to a reckless operation. Mr. New will plead guilty to both, subject to the court's imposition of fines for those offenses.
Mr. Heald?
Correct. That's all correct.
Okay. So, are you moving them in the OVI?
We will, based on the fact that he's done what he said he would do.
All right, so we amended to a violation of the Ohio Revised Code Section 4511.20 without due regard to the reckless stop statute. And what plea does your client wish to enter Mr. Haslam to the two remaining charges?
He will enter guilty pleas to both, Your Honor.
Is that correct, Mr. Miller?
Yes, sir.
All right. I will accept your guilty pleas and your guilty findings to both. On the speed offense, it's going to be a $150 fine. I'll order you to pay the court costs. And on the, without due regard, it'll be a $150 fine. And there's only going to be one court cost. I don't care whether you put them on this one or the other one. Is he planning on paying that today?
Yes, Your Honor.
All right, so if he pays that today, there will be no probation. But I'm going to set a review date in case of January 29th of 2027. would note that the DIP school was completed and there was an AOD assessment.
State the OD assessment. Good.
Good. And on the speed, it would just be $150 fine. All right, Mr. New, you're going to need to see the clerk before you go. And assuming that you pay that today, that review hearing dated for January 29th will be vacated and you not need to treat.
Understood. Thank you, sir.
Thank you.
All right, thank you, Your Honor.
Thank you, Mr. Chairman.
Mr. Chairman.
State of Ohio versus Brandon Losey, case number CRA 26164.
3 weeks.
All right, this is State of Ohio versus Brandon Losey, CRA 26164. This is Mr. Smith's case. That is a pre-trial.
Judge, I spoke with my client, Megan Dower. He is looking to go into the QRT program. I'm assuming he's doing well currently.
Yes, he's doing well with OVP outpatient.
We can come back that August 21st date. That'll give him a chance to get in QRT, and hopefully we can dismiss it on the 21st.
All right. I'll set this matter for another pre-trial August 21st, 2026 on defendant's request. I'll note that he may be going to the QRT program, and that'll be at 10 a.m.
Thank you, Your Honor.
Right, okay.
Thank you.
Thank you, Your Honor.
State of Ohio versus Julie Pritchard, case number TRC 26658 A and B, CRA 26253.
All right, this is State of Ohio versus Julie Pritchard, TRC 26658 A and B, CRA 26253, CRB 2691. Mr. Smith's case set for a pre-trial today. State's represented by Attorney Phillips.
I'm in treatment.
Where do you go?
Fresh start. I can take the screen today if needed.
All right, well, we want you to continue doing that.
Absolutely.
What we're talking about, there's a felony charge which the state is willing to not only that in return for a plea to the OVI and the DUS, which is
And the theft.
for an OVI, and there's a theft charge. But in essence, she would have to do 3 days jail, considering the DUS is for an OVI. So she wouldn't do the school, but we talked about the assessment. Apparently, she's already in treatment at Fresh Start. Where is that?
It's in Ashland.
It's
I'll
in-
give you the paperwork on it.
Okay, yeah, and I've printed you paperwork before. It's in Ashland, Kentucky. I don't know if somebody's familiar with it here.
I was just in a car wreck. I was in surgery for 6 hours. I got back to the doctor in a week.
Why don't we do this then?
Yeah.
Let's come back August 21st. That'll give Mr. Smith an opportunity to get the paperwork. In fact, Fresh Start, because we want to know that you're in there and doing well. I don't doubt that. That also gives you an opportunity to go back to the doctor and potentially get healed up before you have to go into the would have to go into long-term jail.
And we'll set up your time.
We'd like to get their plea today, if that's possible.
Yeah, we could take a plea.
I don't mind to come back for sentencing on the 21st, yeah, because she's, wants to do this, she's committed to treatment, she's, so obviously it'll benefit her to have that when she's sentenced.
Can I get
On the-
something drawn up report?
Yes.
Let me see, August 21st.
And Judge, she is seeking a permit for work and for medical purposes. And I suppose also community service, court hearings, those type of things. Did you have insurance on the car?
Yes.
All right, Mr. Smith, on the, let's go through the 26, 658 A and B first.
The 26th.
He's going, it's the case number.
All right, on the DUI, how did, the DUI and the driving under suspension, how did your client wish to plead?
No contest charge or stipulation of facts sufficient for a guilty finding in both charges, or on both charges.
All right, so, noted. Accept or guilty, is that what you wish to do, ma'am?
Yes.
All right, I'll accept your guilty plea and enter guilty finding. On the CRB 2691, that I believe is a theft case. How's your client wish to plead?
Same judge, no contest with stipulation of facts sufficient for a guilty finding.
I will accept her no contest plea and I'll go guilty finding on that. And Mr. Hill, based upon that, are you moving to knowledge the CRA 24, or 26, 253 case?
We are, Your Honor, but we also want, I think it's already understood, but I just want to say it for the record that we have concerns that she does need to follow through with the treatment, so we're going to ask for that to be part of the ultimate sentence in that, so hopefully she keeps up with that in the meantime.
Okay. All right, based upon that, the 26, 253 will be nollied at state's request. The understanding that she's going to be continuing the treatment that she's already in. Ms. Pritchard, they're entering what's called a nollie on that, which means if you don't follow through with your end of the bargain, they can refile that charge.
Okay.
So you're getting the benefit of that right now. We're going ahead and just basically dismissing it at this point to your benefit, but that could come back if you don't follow through.
And Judge, she will get a progress report from her provider, bring it to the next hearing.
Absolutely.
All right, I'm going to set you back August 21st, and that'll be a sentencing hearing.
Yes, appreciate it, Judge.
All right, thank you.
Is she allowed to get the driving permit, Judge? She says it should be insurance marked on the ticket she had. Work and medical.
She's got a driving under suspension on there, so I can't give privileges for that.
Thank you. You're right, Judge. Thank you, Ron.
All right, thank you.
State of Ohio versus Sarah Jennifer Means, case number CRB 26419. This is Mr. Steyer's case, and Mr. Smith is standing in.
All right, this is State of Ohio versus Sarah J. Means, CRB 26419. Going to be Mr. Smith's case today. And the state's represented by Attorney Phillips.
Yeah, and on there, we could only go back to 2020. Yeah.
Judge, I'm just talking to her, she's, first of all, is going to pay $100 today, she owes on her fines and court costs, and I told her to work with the clerk as far as getting on payments.
Doesn't appear there's going to be on this case.
All right, so, I mean, I'm glad she's doing the treatment, but it's Luke's case, right? So unless she wants to plead today, if she were to plead today, all we wanted to do is just keep doing her treatment, which she's already been doing for a long time. And I think probably the court would order her to do some community service.
Do you want to come back and talk to Luke? Go ahead and do that. She's not asking for you.
Well,
Okay, let's come back. I'd feel better if you talked to Luke, since you want to talk. Judge, we probably will do that, but she's not had a chance to speak with Mr. Steyer due to his situation or her schedule, but I would feel more comfortable if she talked to Mr. Steyer. I think it's going to get resolved, but just not today.
Okay.
In his schedule, the bad dates in August are the 21st and 24th are the bad dates.
Okay.
So anything else, he's available.
Through August 28th at defendant's request.
I'll write down. Make sure you get a hold of Luke before the 28th.
yeah.
That'll be a pretrial at 10 a.m.
Pretty much. That's a date. 18th. Call, you want his cards? You need a card? That's what you want. He's kind of busy now. If you call him, that's a month. We'll get you. Okay. You're good to go. All right.
State of Ohio versus Richard McMillan, case number TRC 26340 A&D. Richard McMillan.
Or this is State of Ohio versus Richard McMillan, TRC 26340 A&B. This is Mr. Steyer's case. Mr. Smith is standing in.
He is judge. I spoke to Mr. Hill this morning. It's my understanding, we did a little research, that this was actually nollied on June 29th of this year. So I think we're done.
The reason it was set back today was because part of the reason why we agreed to nolly the charge was based on the fact that the young man was applying to be admitted into the military, and he was to take the test, and apparently he has taken the test but not passed the test. Also, the contraband, or the prohibited substance in his system was THC only. There were no other substances. Not that that's not bad in and of itself. However, that coupled with the fact that there were several indicators maybe that we wouldn't be able to prove the case, we decided that we would nolly the case. If he didn't do what he said he was going to do, we were going to refile the case. We still reserve the right to refile the case, but for right now, we consider it nollied.
All right. This matter has already previously been nollied, so we're going to leave it at that.
Thanks, Judge.
Thank you.
State of Ohio versus William Spalding, case number TRD 26338 A&D, CRB 25601, ABCD and E, CRB 23512.
This is State of Ohio versus William Spalding, TRD 26338, AMD, CRB 25601, ABCD and E, CRB 23512. This is Mr. Steyer's case, Mr. Smith standing in.
Your Honor, on this one, I received a text from Mr. Steyer that Mr. Spalding is out of town for a wedding. I certainly understand it does not trump his responsibility to be in court, but I don't know any more than that. I would ask in lieu of a bench warrant. We said as early as next Friday if you want. Surely it won't be a week-long wedding.
Well, I'll go ahead and, Mr. Hill, anything you wish to say about this?
It could be a week-long wedding. It just depends on who the wedding is. They just had one in New York that lasted a week.
All I notice it says wedding out of town.
Forget that girl's name, the singer, and the football player. But I doubt he went to that wedding.
Oh. Well, we just been informed Mr. Spalding came in yesterday and made payment.
Well, he must have left yesterday afternoon, I don't know. I just got the notice that
He made the payment, he went and got his tux, and he's out of town.
he could have been at Skeffington yesterday. Yeah, all I know is I got a notice that says he's out of town. Could you please be excused today?
Why don't we do this? Let's do bench warrant 7 days.
Okay, that's as long as he got an opportunity, that's fine.
Yep, the bench warrant 7 days at the end.
That'll work.
State of Ohio versus Melissa Calico, case number TRC 261336 A, B, and C, set for argument.
All right, this is State of Ohio versus Melissa Calico, PRC 261336. A, B, and C. Ms. Calico?
Yes, sir.
It's alleged that on or about July 29th, 2026, in Union Township, you were operating a motor vehicle under the influence of alcohol, drug abuse, or a combination thereof, and you submitted to a urine screen. That's an alleged violation of Ohio Revised Code Section 4511-19A1A. That is a misdemeanor of the first degree. Maximum penalty on that is up to 180 days in jail, a $1,075 fine, 3-year license, and 3-year license suspension. The minimum penalty on that is 3 days in jail or 3 days in a drug intervention program, a $565 fine, or a 1-year license suspension. On the B case, it's alleged that on or about the same date, same township, you were operating a motor vehicle with a suspended driver's license. That's an alleged violation of Ohio Revised Code Section 4510.11A. That's an unclassified misdemeanor, maximum penalty is up to a $1,000 fine and up to 500 hours of community service. In the C case, it's alleged that on or about the same date, same township, you were operating a motor vehicle and violated Ohio's tail light law. That's an alleged violation of Ohio Revised Code Section 4513.05. That is a minor misdemeanor, maximum penalty is up to $150 fine and court costs. How do you wish to plead?
So at this time, I think I will say not guilty.
Okay.
Yes, sir.
If you're unsure of what to do, you should enter a not guilty plea. I'll accept your not guilty plea. Do you have money to hire an attorney?
I do not, but I do have a job. So
Okay.
I just don't know like what the guidelines are, on that or whatever. So
Okay. Are you paid hourly?
yes.
How much you paid hourly?
15.
And how many hours a week do you do?
40.
Do you have any dependents?
Me and my son.
Okay. Looks like you are right on the line to qualify.
Okay.
So I'm going to go ahead and appoint Mr. Stratton to represent you.
Okay. All right, thank you.
Hey, Melissa.
Hey, how are you?
Good.
Okay.
Did you post the bond?
Yes, sir.
Okay, great.
Yeah, we've only got the
Yeah, I just wasn't sure how to play it.
Miss Calico.
Yes, sir.
We still, looks like there's a couple of other charges that are coming with this that haven't made it out yet.
Mm-hmm.
Okay.
I will likely be appointing Mr. Stratton to represent you on those as well, but I'm going to order you not to depart yet. Have a seat in the back. And we will, when those charges come out, we will recall that. I'll go ahead and set everything all together. So
Okay.
I'll recall this and we'll do the initial appearance on those as well.
Okay.
And we'll set everything.
I'm a little confused about that.
Don't worry about it.
Okay. I'm really,
Just have a seat in the back.
Okay.
I'm not going to jail today.
Hey, you think I can go to the restaurant?
Yes, you can do that. Yes.
Oh, yeah, they are in there.
Okay.
They're supposed to be put in a separate file, but
We have the additional charges?
we do.
Okay.
Oh gosh, I'm so scared.
All right, first one is CRB 26471A. And Mr. Stratton, I would intend to appoint you. If you want to approach and look at them, I don't know if you would want to waive in and the like, but I'll give you the opportunity to take a look at them so you can see what you're dealing with first.
I was a little scared because I've never been in trouble, and so I was confused about that.
These are comments now?
I believe those are the court copies, so we'll need to get Mr. Stratton some copies of them.
One of them seemed to be a felony.
One of them is a felony, that's the CRA 26470. Mr. Hill, that's an aggravated possession of drugs.
He should be all the charges. Okay, all right. I got copies, Your Honor.
Okay.
Has to be set for prelim/pretrial. The state would indicate whether they would be okay with leaving these cases here. The low-level, one's a low-level felony. The other seems to be just misdemeanors.
We would be willing to definitely consider doing that. But we also, because there's indication there might have been drug use going on, we want Ms. Calico to be assessed for treatment if she wants that consideration.
Most definitely, most definitely.
Yes, yeah.
Okay, somebody wants this. All right, so what we're going to do, Ms. Calico, I am going to set you back for a pretrial and preliminary hearing on August 21st at 10 a.m.
Okay.
As part of the
thank you.
bond, I'm going to continue the bond, and ma'am, which provider are you with?
Focus Residential.
Okay. I thought it was Focus, but I want to make sure.
Yes.
Because I had actually been praying about treatment and then I got arrested.
All right, so I'm going to order you as part of your bond to go and seek out an AOD assessment with Focus.
Yes, sir.
She will talk to you about that here
Yeah.
today. I doubt they're going to do that today, but they will probably talk to you about it
Yeah,
today.
okay.
And you'll need to bring proof of that when you come back.
Yes,
As
sir.
part of this, whatever they recommend, you're going to have to do.
Yeah.
If that's outpatient treatment, you got to do it. If that's inpatient residential treatment, you got
Most
to do
definitely.
it. Okay?
Yes, sir.
And it's going to be part of your bond.
Okay, thank you.
All right.
Okay.
Go and talk to her, but don't leave until I come out.
Okay, all right, thank you. All right, thank you, sir.
I'll be out.
Have a good day.
When are we going to come back?
The 21st.
August 21st.
So that'll need a time waiver.
We'll wait time.
Time waiver for the record.
Your Honor, record of the Lawrence County Jail is going to do. State of Ohio versus James R. Franklin of the Lawrence County Jail, case number CRA 26465.
All right, this is State of Ohio versus James Franklin, CRA 26465. Mr. Franklin, or is that you, Mr. Franklin? All right, Mr. Franklin, can you hear me? Can you hear me, Mr. Franklin? Looks like it's frozen. No, it's still on the middle. On something else.
It looks like it's still frozen. State of Ohio versus Victor Boatwright, case number CRB 26397, A and B. This is Mr. Stratton's case.
All right. We could have Mr. Stratton in the courtroom. I know he just walked out on the arraignment.
David Smith.
The State of Ohio versus Victor Boatwright, CRB 26397, A and B. Mr. Stratton's case, that is pre-trial.
Yes, Your Honor. It's actually, he's at Restoring Hope. Anymore? You got now.
David Smith.
So when do you think he'll complete? So explain to me. I know it's current Fleming.
Yes. That was from an old case that I was on parole way back in Michigan. It was horrible.
They probably put you in Reed's that way. It's probably what they
Yeah,
did.
that was a mishap.
But this is your legal name.
Yeah.
Your Honor, that is his legal name.
Which one?
Corinne Fleming.
Okay.
The name that the court has, Victor Boatwright, is it might be in Leeds that way as an alias of a name he had a long time ago in an old case in Michigan.
Back in 92.
In 1992.
Mr. Gill, have you seen these? Have you had an opportunity to review these?
From Crossroads?
There's from Restoring Hope and from Crossroads.
I haven't seen Restoring Hope.
I'm going to let Mr. Hill review those so that we're all on the same page. We'll try to sort this out.
I haven't seen this right. Did it? I'm assuming that Crossroads, since they have his name on there as Mr. Fleming, that you have verified that, enrolled him, and verified his, whatever information you knew, verified that that is his identity.
And that was the old case back in 92 that I had caught in Michigan.
Yeah.
And that was the name that I had parole from that, I'm saying years ago. That'd been years ago.
So he's not denying that he's also Victor Boatwright, but that's just an alias from that period of time.
So where is he presently, I guess is my first question.
Oh, he's at Crossroads.
He's at
Okay, he's at
Crossroads.
Crossroads.
Yes, sir.
presently. Okay. And ma'am, are you from Restoring Hope?
Yes, sir.
Okay. Anything that you feel that the court needs to know?
When we acquired him from this court, I picked him up, person from the jail made sure to tell me that his name is not Corinne Fleming, that it is Victor Boatwright. I tried to have several conversations with him, and he got very adamant that it was not. To the point he said I could dig up his dead mother to find out, and I'm not willing to do that. So,
Seems a little unreasonable.
yeah, a little bit. The second time I talked to him about it, he decided to leave the next day.
Mr. Heel? This is a pretty unusual situation.
Well, he's in treatment. I mean, I don't know what the first thing that needs to be determined is, whether we're satisfied with one name or the other as being his name, or...
I was going to say, I've got a note here on the, in the court file that says he was arraigned under both names, but...
And I explained to
looking
him,
into this today, so...
an old case back in '92, you know what I'm saying?
Your
I
Honor.
never denied that.
Yeah, he doesn't deny that's not him. He's just, that he goes by Mr. Fleming now, and there's nothing inappropriate by that, I don't think.
Yeah, I think we arraigned both names.
Okay.
So any other thoughts, Mr. Heel?
Well, with respect to him being in treatment, we're satisfied with that
Okay.
for the time being. There is the charge of assault that's pending that's going to have to be dealt with. But that doesn't have to be dealt with today unless they're ready to.
He's established in treatment, Your Honor. Let's see how he does in treatment. And then one way or the other, maybe next time we'll decide how we're going to proceed with this assault charge.
All right, so, kind of talk directly to you, sir, on this for a second. You were ordered to Restoring Hope, you left. You're now in Crossroads. Now, I'm not going to change that because I would imagine from what's been said here today that Restoring Hope probably doesn't want you back at this time anyway. Hang on, let me finish now for just a second. So I'm not going to upset that. I'm going to let you stay at Crossroads. However, I would caution you going forward. You're not going to be able to change on your own going forward. If you have a problem at Crossroads and you wish it to be addressed, you'll need to contact your attorney. He can bring it before the court, and then the court will make a determination on whether you need to be somewhere else or whether you need to remain at Crossroads. We'll start there. So I'm going to schedule you back August 24th, and that'll be a pretrial at 10 a.m.
Okay.
And then perhaps, between now and then, there'll be some form of determination as to the correct name.
What's the next
Not
date?
particularly convinced either way.
24th.
Quite frankly, it's not really before me at this point today, other than to say the determination on the pretrial and the sentencing. So I will leave that to the wise decision-making of Judge Capper the next time we're here. So we'll be back on August 24th at 10 a.m.
Yes.
State of Ohio versus James R. Franklin at the Lawrence County Jail, case number CRA 26465.
All right. This is State of Ohio versus James Franklin, CRA 26465. Mr. Franklin, can you hear me?
Yes, sir.
All right. Mr. Franklin, it looks like you're here on an extradition matter. The Commonwealth of Kentucky looks like has a warrant for you out of Boyd County Circuit Court.
Yes, sir.
All right. So you've got a couple of options here, and I can appoint an attorney to represent you if need be on this matter, but you have the right to force the Commonwealth of Kentucky to come produce a valid governor's warrant, and before that, you can be extradited back to Kentucky. Now, they've asked that you be held on no bond as part of this, and so you would likely be sitting in the Lawrence County Jail for whatever period of time it took to get, for them to do that, up until there's a limit on time, and I believe that's 60 days for them to do that. If you go that route and after 60 days they haven't picked you up, you would be discharged from the Lawrence County Jail. That would not get rid of your warrant, and you could be picked up on it that same day in theory. The other option that you have is you are free, if you wish, to waive that requirement and say, yeah, I'm the same James Franklin that they're looking for in Kentucky, and I want to go back and face the charge there. If you do that, I will give the state of Kentucky 1 week to pick you up. And if they haven't picked you up by that time frame, we'd have you back in court on that a week later, and you would be dismissed, which it would be the same thing. It wouldn't get rid of the warrant at that point, and you could be picked up on it again. But if you want, if it is your intention to say, I'm the person that they want, and I wish to get there as quickly as possible to face that, then you could waive that extradition hearing, and I would, like I said, give them a much shorter period of time to come get you.
Yes, that's the route I want to go, sir.
Okay, so after hearing my explanation, do you feel like you understood my explanation?
Yes.
And you're indicating to the court that you want to waive your right to an extradition hearing?
Yes.
All right. So I will find that you've knowingly and voluntarily waived your right to an extradition hearing. There will be a form that is going to be sent to the jail for you to sign. And I'm going to give them until, I'm going to note the waiver, I'm going to give them until August the 7th to pick you up. If you have not been picked up on August 7th, we'll have a pretrial here at that point, and presumably you would be dismissed. So I'm going to set that for pretrial. If they pick you up before then, when that pretrial comes, the jail will inform the court that you have been picked up, and we will dismiss the extradition matter here. And I will conclude everything with this court.
All right.
All right, so I'm going to go ahead and set it for a pretrial August 7th at 10 a.m., and we will take up the matter again at that point if you are still in the Lawrence County Jail.
Thank you, sir.
All right, thank you, Mr. Franklin.
State of Ohio versus Jason Harrell at the Lawrence County Jail, case number CRA 25427, CRB 25428 A and B, CRB 25429 A, B, and C. Derek Keaton on deck.
All right, Mr. Harrell, can you hear me?
Yes, I can hear you.
All right, this is State of Ohio versus Jason Harrell, CRA 25427, CRB 25428 A and B, CRB 2549 A, B, and C. This is Mr. Smith's case. He's present in the courtroom. And it looks like there was a failure to appear on these matters back in April of 2026.
Can I say something, Your Honor?
Well, you just don't talk about the case. Are you willing to go to treatment?
Yes, I'm willing to go back to treatment. I've been in jail since March 30th.
Okay, hang on just a second.
That was my understanding, was that...
TPC is willing, correct?
Yeah. That was my understanding, is that he was kind of shipped off to another county, and it's been a lengthy kind of period of incarceration. I think it was Adams County.
Yes, I got that all cleaned up, Your Honor.
The counseling center is willing to take him, I'm assuming pick him up from the jail and have a bed and all that stuff?
That's correct. All right.
That's what I would request, Judge.
All right, any objection to that, Mr. Keel?
No.
All right, Mr. Harrell, you're willing to go back to treatment at the counseling center?
Yes, Your Honor.
Okay. All right, my understanding from speaking to the counseling center this morning is they do want you back, they're willing to take you back. So I will allow that. I will set a bond at 2,500 OR. Release the treatment at the counseling center only. And we'll come back. I'll give him some time in the program. What's your calendar look like at the beginning of September, Mr. Smith?
I've got a couple of things, Judge, but I should be able to find some time. Let's see.
How's it for the 4th?
It should be. It's a Friday. I'm here anyway.
Okay. All right, I'm going to set you back, Mr. Harrell, for September the 4th. It'll be a preliminary hearing, pre-trial at 10 a.m.
Get a good report, Jason, okay?
Okay, I've been incarcerated since March 30th, 2026. I just got released from there 3 days ago, and I have one out for me for here, so they brought me here. And I had the counseling center almost completed. I was in transitional living. I was doing great.
They're going to pick you up, so make sure you get a good report, okay?
Yep.
All right.
Okay.
And I'll report any warrants that were out here from this court.
Thank you, Judge.
State of Ohio versus Derek Keaton at the Lawrence County Jail, case number TRC 261340A and B. And Tracy Berry is on deck.
All right, this is State of Ohio versus Derek Keaton, TRC 261340 A and B. Mr. Keaton, can you hear me?
Yes, sir.
All right. Mr. Keaton, we're going to go through your charges here on this, and then I'm going to ask you for a plea. You can enter a plea of guilty, not guilty, or no contest. If you enter a guilty plea, you're making a complete admission that you committed the offense charged. If you enter a not guilty plea, you're denying that you committed the offense charged. And if you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not denying the facts surrounding it. And if I think the state would otherwise have enough evidence, I can enter a guilty finding. If you are unsure of what you should do, you should enter a not guilty plea. You have the following rights before the court. You have the right to remain silent. We're recording everything today. You have the right to have an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at no cost if you qualify. You have the right to have a reasonable bond set in this matter. And you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You feel like you understand my explanation of the pleas and your rights before the court?
Yes, sir.
Okay. Mr. Keaton, it's alleged on or about July 31st, 2026, in Perry Township, you were operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof, and that there was a breath test score of 0.277. That is both a violation of Ohio Revised Code Section 4511-19A1A and 4511-19A1H. That is a misdemeanor of the first degree. This is also a second offense. It is a misdemeanor of the first degree. The maximum penalty on that is up to 180 days in jail, a $1,625 fine, a 7-year license suspension, immobilization of the vehicle if it is registered to you. There is special plates required and an interlock device required. On the minimum penalty on that is 20 days jail or 10 days jail and up to 36 days of home confinement, a $715 fine, a 1-year license suspension, Mobilization still required, special plates and the interlock will still be required. On the B case, it's also alleged on July 31st, 2026 in Perry Township that you failed to drive within marked lanes. That's an alleged violation of Ohio Revised Code Section 4511.33. That is a minor misdemeanor. The maximum penalty on that is up to $150 fine and court costs. How do you wish to plead on these charges?
No contest.
Okay, so you're not admitting that you committed the violations,
Yeah.
but you're not contesting the facts surrounding the violations, and you understand that if I think the state would otherwise have enough evidence, I can enter a guilty finding. And you do understand that if you do that, you will be sentenced to a period of jail time based upon how you're charged.
Yeah, so I have to do jail time today, is that what you're saying?
If you enter a no contest or a guilty plea, and I find a guilty finding, there is a minimum penalty on this of 20 days jail or 10 days jail and 36 days home confinement. So if you're unsure of what you should do, you should enter a not guilty plea, but I just want to make sure you're aware that if you enter a no contest plea, you're likely going to be spending time in jail.
All right, no, plead not guilty then.
Okay, I'll accept your not guilty plea. Do you have money to hire an attorney?
No, sir.
Are you working?
Yes, sir.
All right, where do you work?
Engines?
Okay, are you paid hourly?
Yes, sir.
How much you paid?
16.
Get 40 hours a week?
Yes, most time.
All right, do you have any dependents?
Yeah, I have a daughter.
All right. You're right on the line, so I'm going to find that you qualify. I'll appoint Attorney Sean Stratton to represent you. And Mr. Hill, do you want to be heard on the matter of bond?
Well, this happened just this morning, I think.
I believe
Right
so,
after
yes.
midnight. And,
just after midnight.
So,
And I don't know if you saw, it's a second offense with a breath score of .277.
I did see that.
Okay.
I guess I wouldn't have expected him to be in jail unless he's there for his own safety, maybe, I don't know.
I'm supposed to work today tonight.
I don't know that there's any reason to do anything other than an OR bond.
Okay. Mr. Stratton? Okay.
Yeah, we don't disagree with that, Your Honor.
All right. Mr. Keaton, I'm going to set you a $5,000 OR bond in this matter, so you'll be able to sign your own bond to get out today.
Okay.
I am going to not just caution you, but I'm going to order you that you're suspended at this point, and there's not a possibility right now for you to get privileges as charged. I'm not just going to caution you, but I'm going to order you not to be driving.
Yes, sir.
In addition to, if you were to drive, if you were to drive and you got caught on that, there is another charge, which would be driving under an ODI suspension, that would go on, and the minimum penalty on that is 3 days jail. But with that score, I'm going to go ahead and tell you that you're not likely going to end up with a minimum penalty if you do that after I've warned you not to drive. You understand?
Yes, sir.
All right. At the appropriate time, and based upon once he's reviewed everything, Mr. Stratton can certainly petition the court for relief from that. But at this point in time, that's going to be the court's order. Mr. Stratton will be able to speak with you after once he'll either call you to jail or once you're released from jail. Is there a good number for him to reach you?
You talking to me?
Yes.
Yes, 740-547-8200. Sorry, I didn't know if you're talking to him or me.
That's okay. I'm going to set you back for August the 24th for a pre-trial at 10 a.m. presently in jail, so we don't need a fingerprint order.
All right, thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you, Mr. Key.
State of Ohio versus Tracy Berry, case number CRB 26469.
This is Mr. Steyer's case.
All right, this is State of Ohio. Oh, no. Mr. Smith, this is Tracy Berry. It's not on yet, but there's a new charge for violating the protection order that's going on. If you would just,
If I may just thank you, yes.
I've got a copy in the file, so.
No, sir.
All right. Ms. Berry, can you hear me?
Yes, sir.
All right, this is State of Ohio versus Tracy Berry, CRB 26469. Ms. Berry's present via Zoom. Her attorney's Mr. Steyer, but Mr. Steyer's not present here today, but Mr. Smith, Roger Smith, is appearing on Mr. Steyer's behalf. Ms. Berry, we're here on a new charge today. I want to go through a few things with you. I'm going to go through the charge with you, and then I'm going to ask you, I'm going to assume that Mr. Smith is going to enter a plea on your behalf at that point.
Yes.
But I want to go through the charge and tell you the maximum penalties involved on that. So, Ms. Berry, it's alleged that on or about July 29th, 2026, you did recklessly violate a term of protection order issued or consent agreement approved pursuant to section 2919.26 for 3113.31 of the Ohio Revised Code in violation of section 2919.27 of the Revised Code. That is violating a protection order consent agreement. That is a misdemeanor of the first degree. That carries a maximum penalty of up to 180 days in jail and a $1,000 fine. Mr. Smith, on behalf of the client.
Judge, this time I would enter a not guilty plea on behalf of Ms. Berry. Ask that bond be set and it be set for a pretrial on one of the days that Mr. Steyer is available.
All right, I'll appoint Mr. Steyer on this matter. Mr. Field, that's for the matter of bond.
Your Honor, she's already being held. This happened while she was in the jail. I don't know what her current bond is. $5,000 cash surety bond. So, I mean, that's probably sufficient. The allegation is that she called on the phone the victim of a prior charge. And we've got a recording of it already. We take it very seriously. This young lady just keeps on harassing her neighbors and whatnot, even from the jail. I don't know what we would do about it, but
all right,
except keep her in jail.
Your Honor, I understand the state's position. I don't take a position on bond at this time. Mr. Steyer may take a position at a later date. The bad dates for Mr. Steyer are the 21st and 24th of August. So
August the 3rd, she's coming back already for that hearing.
then
On August 3rd, okay.
I'll let Mr. Steyer, that's one of his good dates.
All right. Ms. Berry, this was, I believe, an order out of this court's case. And I don't know whether you violated it or you didn't at this point, and I'm not presuming one way or another. All I've got is an allegation. However, the court does take these things seriously. So for now, I'm going to set a bond at $10,000 cash as surety.
Can I use my property, sir?
Not at this time.
Okay, that will stay for here as well.
And so we're going to set you back on August 3rd, so you'll be back before the court Monday. You'll have an opportunity to speak with your attorney at that point, and bond can be revisited at that time. But for now, you're going to be held on a $10,000 cash surety bond on this matter. And that'll be a pretrial set at 10 a.m.
All advise Mr. Styer, Judge. Thank you.
All right, thank you, Mr. Smith.
Your Honor, we're finished with Lawrence County Jail.
Okay.
State of Ohio versus Charles Baldwin here at the court, case number TRC 26319, A, B, C, and D.
This is State of Ohio versus Charles Baldwin, POC 2621, A, B, C, and D. Is Mr. Stratton's case set as pre-trial.
Set for trial, or do you want to?
Yeah, I'm a grand jury. I shouldn't even be. I mean, you guys are wavering all my evidence.
Your Honor, we'll need to set this for a bench trial.
Okay.
I have never
Mr.
told you
Keel?
nothing.
When would you,
I've been to your office
when would you
twice.
be ready? Looks like it's been set for trial one at a time.
Well, we would be ready about any time, except that I don't know right this minute whether our witnesses, would all be available on the day that we pick. We may have to ask to move it.
Understood. All right, well, I will set this, I'll give you, trying to look for a, let's set this for the 21st, August 21st, and that'll be a trial at noon. And
Does the state indicate what about the possession charge?
On the possession charge, Your Honor, we got results back from the lab, and they did not identify any contraband. So that charge will be nominal. It's just the OVI charge.
all right. The only charge I had here that I could see was the OVI charge.
Yes.
But I'll note for the record, state if there was another case, then there would be a CRA. And maybe it had already been modeled. Okay. So on the TRC case, there'll be a trial August 21st at noon. That's been a trial.
All right.
All right, thank you.
And Your Honor, I'm sorry.
It was not.
What?
Okay. Well, all right, so it's your intention to nominate the CRA 26111?
That's correct, Your Honor.
The felony, Your Honor.
Sorry?
The felony.
Yes.
Yes, yeah, so
All right,
felony's
that'll
gone.
be nominated at this time of state's request.
I would also ask to have a pretrial prior to the 21st of August, if we may.
All right. When did you like the pretrial set?
Sometime, I don't know, a week before, if Mr. Stratton and his client are
August
available.
14th?
Yes, August 14th. You see it.
All right, so I'll note that there'll be a pretrial on August 14th at 10 a.m. and the trial scheduled for August 21st at noon.
Excuse me, Your Honor, I got something to say. Let the record.
I will go ahead and caution you real quick that you are free to say anything you want. I won't stop you, but you may want to run that by your attorney before you do, because everything is being recorded. And so if you say something that is against your interest, that can be used against you. Do you feel like you understand that?
Yes.
Okay. So it is now up to you as to how you wish to proceed on that.
I will hold my tongue.
Okay, understood. All right, so we'll see you back August 14th, and then trial August 21st.
All right, thank you, Your Honor.
Thank you, sir.
State of Ohio versus Justin Bruni, case number CRB 2627, CRB 2662.
All right, this is State of Ohio versus Justin Bruni, CRB 26227, CRB 2662. These are Mr. Stratton's cases, and set as pretrial.
Your Honor, I'd just like to reset this for a pretrial. Me and Mr. Bruni have not had the opportunity to speak about this case and to get the evidence from the state. The state has provided an offer, but...
Can you speak a little about it?
Yes.
All right. Were you available August 24th, Mr. Stratton?
Huh?
Were you available August 24th?
No.
Okay. August 31st?
August 31st would be better, Your Honor.
August 31st at 10 a.m. for pretrial.
Address these two things briefly. I believe they haven't been in contact with the one accuser. Say, come on, I guarantee you they can't cite any contact with her.
Your Honor, maybe the state can confirm or deny whether they've had contact with the alleged victims in this case.
We've been in contact with one of them recently, yes.
What about the other one?
It's been longer since we've had contact with them.
Have you had contact since the pendency of this case?
Yes. Mhm. Okay. Well, what we would do is subpoena that person, and if they don't show up, then we won't be able to proceed. The other one for sure.
Somehow during the process, you I would like it on the record that my information was shared by somebody from that office outside of the context of just a big thing, but I kind of need to find out where it went to, and if it is going to affect the case, I don't know that it would.
We'll have to talk about this one. Okay, I'll keep this. Okay, 'cause that has. We're good, Your Honor.
All right, thank you.
State of Ohio versus Jasmine Green, case number CRB 26374. Jasmine Green.
What's the next hearing date on this?
August 31st. August 31st. This is State of Ohio versus Jasmine Green, CRB 26374. Jasmine Green.
Your Honor, Mr. Stratton was given a note that she was up on waiting on a tow for her car.
Yeah, she was stuck on the side of the road, Your Honor. I'm not for sure if this, I know what the state was thinking about doing with this case. She's not here currently, so I'm not sure what how the state wants to proceed.
We wouldn't be opposed to a warrant being issued in a week if she doesn't show up.
I'll note her failure to appear. I'll note there was possible car trouble. I'll be a bench warrant issue if she hasn't appeared within 7 days.
All right. State of Ohio versus Thomas Horn, case number CRB 26275, CRB 26218.
Should be up on the screen, Your Honor. I believe he is, it's like he's in the list.
All right, this is CRB 26275 and CRB 26218. State of Ohio versus Thomas Horn. Mr. Horn, can you hear me? It looks like you're muted. You're muted, Mr. Horn.
Ms. DeMint here. Brianna.
She was.
She's still here.
Mr. Horn, you're still muted. You're muted.
Yeah, he works out of town, in the trees.
All right. Yep, can you hear us?
Yes, sir.
Okay.
Thomas Horn. You're supposed to get an assessment.
Yeah, I never received his report. Where did he do his assessment at?
Mr. Horn, where did you do your assessment?
Like which location?
You
That was in Proctorville.
Proctorville. I can call them.
Yes.
I just never received it.
I seen my counselor last Friday, but Dr. Thomas wasn't in.
Okay.
You want to recall it, Your Honor?
We can recall it, we can reset it, however you wish to proceed, Mr. Stratton.
Your Honor, we could reset it, allow him to continue, and then we'll just have a report next time.
Mr. Hill, any objection to that?
if it wouldn't be a problem to get confirmation that he's been there, that would help us agree to continue it.
Okay, we can recall it.
Yeah, I can do that really quick.
All right, Mr. Horn, we're going to recall this in a few minutes. They're going to call and try to get confirmation of that, and then we'll recall you here in just a few minutes. All right, thank you.
State of Ohio versus Nikki Lyons, case number CRB 2649. I believe she is also on the hearing, Your Honor. Nikki Lyons.
All right, Ms. Lyons, can you hear us? I see you nodding. Can you answer audibly?
I can hear you.
Okay.
You need-
Your Honor, you good for a second?
You may. This is State of Ohio versus Nikki Lyons, CRB 2649. They were just commenting that it looked like you needed to get up. I don't know much about it. She ordered to be here. All right. This is going to be set for another pretrial after a brief discussion at the bench on August 21st at 10 a.m. Ms. Lyons, you are ordered to appear in person for that hearing. Do you understand?
I'll get it.
Okay. All right, August 21st at 10 a.m. Thank you.
State of Ohio versus Brandon Scragg, case number CRB 21524, TRC 2715.
This is State of Ohio versus Brandon Scragg, CRB 21524, TRC 2715. And Mr. McKeon, you may approach.
Okay.
An excellent report, Mr. Scragg.
Thank you.
So we're going to outpatient today, Your Honor.
So see how he does in outpatient?
That's a very good step. I'm going to go out a little further because he's done so well.
All right.
What's your calendar look like in September, Mr.?
September is good except the 8th. I think the 8th is the Tuesday hearing. I cannot do it.
All right. How about the 11th?
That'll work.
All right, we're back on September 11th at 10 a.m.
Thank you.
State of Ohio versus Kimberly Spangler, case number CRB 26396, CRB 26224. Kimberly Spangler.
All right, this is State of Ohio versus Kimberly Spangler, CRB 26396, CRB 26224. Kimberly Spangler. That doesn't look like Ms. Spangler was here today, Mr. Scragg.
Yeah, Your Honor, I'd say out 7 days before warrant.
Looks like on the prior case, she failed to appear 6/5 and 6/29 on those. So
She was supposed to go to OVP.
OVP outpatient.
And that was the last hearing.
Maybe while they're confirming the, Mr. Horn, maybe they can attempt to confirm the Spangler as well, since maybe they're already on the phone with them.
So we assessed her while she was in jail to come to inpatient. She was accepted. When we reached out to go get her, they told us that she had to hold her out of common pleas to be sent back to prison.
Well, she may not be here, so here's what we'll do for that. Let's go ahead and issue the bench warrant, and then we'll figure it out once we inevitably and eventually get her back.
We can recall Horn, Your Honor.
Okay. State of Ohio versus Thomas Horn, CRB 26275, CRB 26218.
So he is a patient with our Proctorville office. She said that he hadn't been seen since May up until the 24th. So he did come in for a therapy session then, but he has not been compliant with attending his sessions.
Your Honor, this is a specific situation where he does work a lot out of town. When he's in town, he does attend treatment. If he could possibly do more by video conference, as you can tell, he's working now.
Yeah, I think he just needs to communicate that so that we could accommodate, his sessions and things via Zoom. I know they do that, and if the Proctorville office isn't able to do that with you, our Huntington office does it a lot for people, and maybe we could transfer you, but we could work it out.
Okay, Mr. Horn, you're back on mute again. Can you hear? Could you hear what was being said?
Yes, sir.
All right, so we understand you work out of town. You're going to need to communicate that with OVP because they can do sessions over Zoom like you're doing right now.
All right.
However, if you don't communicate those things with them, then they can't do those things for you. And so I'm, at this point, making it incumbent upon you. This is going to be your responsibility to make sure those things happen. Do you understand?
All right. Yes, sir.
Okay. I will set you back for September 11th for a pretrial. And I expect to have reports by then that you've been doing what you're supposed to do. Do you understand?
Yes, sir.
All right. Thank you, Mr. Horn.
Thank you.
Thank you, Your Honor.
State of Ohio versus Scott Taylor, case number PRC 26858 A&D.
All right, this is State of Ohio versus Scott Taylor, PRC 26858 A&D, CRB 26325. This is Mr. Stratton's case.
Maybe approach, Your Honor.
May. negotiation, is that jail time or this, that's just for court office, and you send them, long term, but that's just for on how it's supposed to be paid. I can understand from, what's been relayed to you, and what's in the file, that's why he's doing that. So I guess the question is, set for Congress, the president.
My earlier recommendations, is partially based on my frustration with this computer. Never fall for it. So I kind of left my personal feelings here with my recommendation. One thing that I didn't remember was that it was been on electronic monitoring now for several days. And it's a similar offense. So
Yeah, it's like you've been on since June 26th, or something, fine.
yeah, so he's got some of that. I think he's deserving of some credit.
The same.
It's a second, if he did 5 years old.
What would you guys say that's charged, it's mandatory time, that's charged.
One say to second. So it's due for surgery and stuff like that.
I was thinking suspended time except for 5 days, if they had to do 5 days, then get credit for it. And then I think that would be your license suspension.
We have to essentially treat it as a low tier, second or something like that. On a high tier of the refusal, it's 10 days minimum. So,
If he were in a, obviously, it's before the court, and your hand says it's then that has influence on our recommendations, but he's never been. So we have to be content. And also be assessed for, and if it was outpatient, that would matter to us. It'd be better for him if he went to residential treatment.
The big house is not what we thought. It's alcohol.
Yeah.
Right. Well, it's alcohol. Right.
so that's a personal question. Do you want to speak a little about Mr. Hill? And then it sounds like it probably is something just wait for a second. Regardless, but which he may have, and going on clock, we're close to 36 days already. Okay, with you, Mr. Hill? Okay.
So we'll take a plea today on the second ABI, and then they're going to set it for sentencing, and then to get an assessment done, an alcohol assessment, drug assessment. Okay?
Your Honor?
Yeah.
Oh, I'm sorry.
At this time, you'll enter a guilty plea to the OVI. And there's also a drug paraphernalia charge, I believe.
At the turn signal.
Turn signal.
There's a right-of-way, or not, it's a right-of-way charge. And I see a note there on the bond form, there was a CRB 26325.
That should be the drug paraphernalia charge.
Okay.
Does the state still want that charge, or will the OVI satisfy the state?
We don't care to nolly the paraphernalia charge.
Yes.
All right.
So we'll
Plea to the OVI, the CRB 26325 will be nolly.
yes. And Your Honor, because of the things we discussed, we asked it be set for sentencing.
Okay. Mr. Taylor, is that your intention to enter a guilty plea to the OVI and the failure to get the right-of-way when turning left charge?
Yes, sir. There's absolutely no way I could, deny that. I mean, I think it's on videotape.
Okay, I will accept your guilty plea, enter a guilty finding, and we're going to set a sentencing hearing for, I'm going to go out a little bit further, September 11th.
But just 1 second, Your Honor. When's your surgery?
September 16th. It's after I go back to Scott orthopedics.
Okay.
That's when they're going to determine. Right now, it's that with Scott, he said tentative on conservative physical therapy for a year. So I'm talking about that.
Your Honor, he does have a surgery date.
No, I don't have one. It is, I go back to Scott. They don't want to do it yet. They want to try to conservative physical therapy on the 20 meniscus.
Okay. He does not have a surgery date yet, Your Honor. But when you go back to the doctor?
September, I believe it's the middle of September. I can't remember on that orthopedic. It's late. It's later part of September.
Is this did you go to OVP?
Yes, I've been going to there. Yeah, I went back to OVP also.
He has went back to OVP, Your Honor.
I've got all these papers.
I do have a letter. His surgery's not planned yet, but if we could set it towards the end of now approaching.
Yeah.
Set it to the last part of September for sentencing. Gives him time to figure out his knee issue.
Let's do September 25th.
That'll work.
That'll be a sentencing at 10 a.m.
September 25th?
Yes. And then that'll give him some time to persuade you, Mr. Deal, with his treatment.
Okay, well, so he already got a treatment provided?
He's an OVP.
Okay.
He just provided some proof to the court of that.
Okay, good.
State of Ohio versus Brian Atkins, case number CRB 26338.
All right, you good to go, Scott?
Thank you, sir.
All right, this is State of Ohio versus Brian Atkins, here in 26338. This is Mr. Smith's case.
It's Mr. Steyer's case, Judge, but I'm covered, yes.
All right. Not sure what that says, so we'll hire somebody. Sure, I can believe that.
Is this a drug
There's a name on here, I'm just gonna cover what it says.
Would he be assessed, would he agree to? I mean, that's the most important thing.
Just reset it for Luke. We'll need to reset this one, Judge. There's been an offer made. Mr. Luke's Mr. Steyer's client's not interested in it now, so I would feel better if we had, give him a chance to talk to Luke before we do something with it.
All right, let's set this for, at the defendant's request, we'll continue this matter to
Yes.
August the 28th.
Okay. I'll let Mr. Steyer. He'll call and get a hold of you. We'll talk for 28. Give his card. Just in case he didn't have it. Okay. There's his contact info. Give him a call until August 28th is your next hearing. And you can get his phone number for that. And we have all four dates.
What's mine? Stress.
That's your next hearing, so get him before that. Good. You're free to go. Yes.
Thank you, Your Honor.
Thank you.
State of Ohio versus Terry Kerr, case number CRA 25332.
Kara Kerr. This is State of Ohio versus Kara Kerr, CRA 25332. So Mr. Smith's case.
I got one. Okay. That's discouraging. Yeah. That's what we're leading right to. Shoot. Maybe getting rid of it today.
All right, I'll give Mr. Smith an opportunity to say anything you wish to say.
Well, I'm disappointed, I will say that. She's been at this is a 25 model. I thought we were possibly even ready to take care of it today, but I don't know. The report is what it is, Judge.
All right, I'll let you tell you if you're on the bench warrant issue immediately for her, because she's high risk.
She left on with him.
Yeah, she was admitted June of last year, so I really,
It was a cash surety bond originally, but then it was amended to OR with GPS.
all right. I guess we'll see her back at some point.
But that may have come on since. Because that was a long time ago that she put on that, so.
State of Ohio versus Raymond Jackson, case number CRA 25352.
This is State of Ohio versus Raymond Jackson, CRA 25352. Smith's case, set for preliminary hearing.
I understand they talked about QRT, but you're about finished with the program, but you're at now.
Yes, sir.
Okay, that's fine.
Yeah, about for like 2 weeks.
Okay. Yeah. Wish you guys told you, I didn't realize you were that close to. That makes sense. That's wonderful. That's wonderful. 2 weeks from graduation. Just come back about a month, make sure you got the finish line, you graduated, you take care of it. So you're so, just keep doing what you're doing. Where's your family?
See, out here, out of this place, I just come back to the court, right?
Yeah, you did come back, and we'll talk, does it get dismissed at that point? If you do what you're supposed to
Comes into Kentucky as well.
do. We'll get that taken care of. All right. And Judge, he's about 2 weeks out or so from graduation. Can we come back sometime towards the end of August? Hopefully he's graduating. I think we can get this one disposed of. He's been doing well.
It's a very good report. How about, I know
Thank
you're here August 21st.
Yes, I can have to look.
Thanks, sir.
August 21st.
Thank you, Your Honor.
10 a.m. for a preliminary hearing.
That's 8.
Thank you.
8:21. 8:21, 26, at 10 o'clock. Thank you, sir. Report, and I'll look forward to getting this done for you.
All right, thank you.
Take care, yeah.
Thank you.
Thank you.
State of Ohio versus Caleb McDonald, case number CRA 2669 A and B.
CRA 2669, Caleb McDonald. This is Mr. Steyer's case. Mr. Smith is standing in. There was a screen today that was done. Have you seen that, Mr.
I have not,
Smith?
Judge, no. I didn't look at it.
So she is in our outpatient office, Your Honor, for level 1 care. She had been discharged from the program for just non-compliance with attendance and positive urine drug screens. She was reestablished on the 29th for services, and they do have her scheduled for intensive outpatient therapy. She's told me she has a job now and everything like that, so I'm not really sure what we want to do from here. The fentanyl is very concerning, though.
I can tell you, Ms. McDonald, that is very concerning to the court.
Yes, sir.
Because we can die from that.
Yes, sir.
If I may suggest, as we come back, like within a week or two, to not set this out too far, given that drug test result, and let her try the intensive outpatient, and I guess the next step would be inpatient, then
Next step would be grand jury.
Okay. I was getting there, I just take a couple steps.
I wouldn't even give her another chance at inpatient. She's got to do it this next time, as far as we're concerned. This is too far.
This has been pending since February, and from what it sounds like, Ms. McDonald, you've not taken very much by way of the opportunity. We're hearing non-compliance, 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 and then you show up here and test positive for fentanyl. And you're not giving the court a lot of options here on what to do with you. I'm concerned. I don't want to send you home and then see you die.
Right.
But, you know, I typically rely on my providers as to what should happen as far as that goes, and I'm being told that the recommendation is intensive outpatient. So I'm inclined to do that, but I do want you to understand that Mr. Gill has indicated this is your last chance. It doesn't even really sound like he thinks that you should have this one. And I'm not entirely sure that I would disagree with him.
Yes, sir.
So if you come back and it's nothing but stellar reports from here on out, I'm sure he's going to take it to the grand jury, and you're going to have a felony, and even assuming that on that felony charge over there you would get some form of preferential treatment, it is still going to be significantly more punitive to get that special treatment than anything that you're ever going to receive out of this court.
Yes, sir.
I mean, you're talking potentially up to 500 hours of community service up in the other courts and different things like that. And that's just to be able to get through. So I'm going to note your intensive inpatient, but no more chances.
Yes, sir.
Okay. All right, I don't want to go too far out on this specifically because I want to make sure you're monitored, so I'm going to set you back August 7th.
That's a good day, Judge. August 7th at 10 o'clock.
Right here at 10 o'clock.
Yeah, 10 o'clock, August 7th.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jonathan Jarrett, case number CRA 2670 A and B.
And Mr. Smith, here's another one. All right, this is State of Ohio versus Jonathan Jarrett, CRA 2670 A and B. Mr. Smith's case.
Okay. And Judge, he indicates the amphetamine positive is a prescription he takes, and the buprenorphine is, he takes the shot, Sublocade?
Yeah, had the shot.
Had the shot. So, I guess that's better than the last one.
And he
Strattera.
is,
And amoxicillin.
he has been compliant with outpatient. He also works, so they have been doing Zoom calls and things like that. So he has also missed some scheduled therapy sessions and things like that, but he hasn't had any positive drug screens, and we can confirm the Strattera. I don't have the confirmation currently, but
Sure.
I can go back and get my prescription and bring it back.
The confirmation from OBP is enough for me. All right, so this is available August 28th, Mr. Smith.
Actually, that's day 2 of a trial with Judge Ballard. I'm here,
24th.
it's...
I think you were here.
24th I can do.
Okay. I was going to say, I thought you were here the 24th, but Mr.
I am in Steyer, yes, I am here the 24th.
All right, August 24th for preliminary hearing, 10 a.m.
thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Richard Gentry, case number CRA 24-107, Your Honor, this case is set for preliminary and pretrial, and the delivery assigned to Mr. Morford, who's now retired.
All right, this is State of Ohio versus Richard Gentry, CRA 24-107, CRB 24-108, A and B. This is Mr. Morford's case. Mr. Gentry, your attorney, has retired. So Mr. Morford isn't going to be here. And perhaps Mr. Smith can stand up here. It looks like we've got a certificate of completion from anger management here. I know you're kind of flying blind a little bit.
A little bit.
I may, if need be, depending on what Mr. Hill has to say, we may just appoint you going forward, or whether we're going to resolve it today, I'm unsure.
Well, is Penny Nichols here?
No, she's home with the baby.
Okay. So they just had a baby, and we've been encouraging Mr. Gentry to follow through and do the anger management counseling, which he has. And you're still living in Kentucky?
Yeah.
So what we'd like to do is, our aim here was to make sure that everything was okay there in the household. There wasn't going to be any more problems with rising from anger and domestic violence and things of that nature. So we'd like to just, let's see, did we get to talk through this week? We'd like to come back one more time and have a chance to make sure that everything's okay there in the household. And we're probably able to dismiss the charges at a later date if there are any further problems.
To get 101 anger management.
Let's do August 24th.
Right, just looking back August 24th, and it should get dismissed at that time.
And I'll make a note that it's probably.
Is that a good date for you?
Normally I don't get paid until the person, I gotta pay somebody to bring me here.
Could we do September? He has to pay somebody to bring him to court, and he doesn't get paid until the end of the month.
I've got no problem with that.
So that first week in September, I'm here.
September 4th?
Yes, I'm here that day. Yes, all right, yeah. That way, it'll be the 4th. That way you should get paid, and you can get somebody to...
How about
September
the other
4th, 10
charges
a.m.
that
for
I got?
preliminary hearing.
I'm not sure what they are, because of literally, I've never even seen your file. What are you charged with?
Assault, and then I think that's for this one, and then I'm charged for discharging a firearm in the city limits.
Well,
But I tried to kill myself.
let me do this. The judge is going to appoint me, so before September 4th, you can call my office, there's my legal assistant, he'll give you a time to come in, and we'll talk about the office, okay? But there's your next court date, is then, but do make sure you make that call.
Okay.
I'm going to formally appoint Mr. Smith.
Thank you, Judge.
I sent Mr. Murphy paperwork.
Now that I've got a point, I'll get the copy of your file from him. I'll get all your paperwork. Call, get in the office. I'll see you before.
Okay.
Well, before the office. All right. Thank you, Judge.
State of Ohio versus Austin Avenue, case number CRA 26252.
All right, this is State of Ohio versus Austin Avenue, CRA 26252, Mr. Stratton's case.
So we're looking at that, right? Yeah.
Good report.
Yeah, all right.
This
best.
This looks ominous.
One earlier.
Continue on, Your Honor.
Very good report. September 11th.
September 11th.
September 11th, for preliminary hearing at 10 a.m.
Thank you.
Thank you.
State of Ohio versus Amber Mills, case number CRA 26132, CRB 26133A and B. CRA 3621, CRB 23556.
This is State of Ohio versus Amber Mills, CRA 26132, CRB 26133, CRB 23661, CRB 23621, CRB 23556. You can motion.
Okay. Your Honor, so she'll be, 6 months will be up in September, into September, so if we can put it towards the end of September.
Sorry.
Yeah, put it towards the end of September.
It's a very good report, Ms. Mills.
Thank you.
How about September 25th?
That'll work. Maybe we'll be done by then.
That'll be a preliminary hearing at 10 a.m.
Thank you, Your Honor.
Thank you.
State of Ohio versus Tessa Stegley, case number CRA 25425, and CRB 25426.
This is State of Ohio versus Tessa Stegley, CRA 25425, CRB 25426.
Excuse me.
Tessa Stegley.
She was with us until early July. She was already committed, and that was kind of, we had some problems from
What's the date?
October 14th.
October 14th?
Yes.
Your Honor, she is in the Adams County Jail
That's correct.
until October 14th.
That's correct.
So I knew she was there, I didn't know how long. So thank you for that. So,
She's not currently in
Let's
services
just
with us
do a
either.
bench warrant for failure to appear, even though we know where she's at, and that way they'll bring her back here. And that would be not a good explanation, but sufficient explanation. Even closer to the present when she's not here, and then we'll get her taken from there. If you want to take her back, we can, I'm assuming we can probably work on that, but I don't know. Circumstances, that's the kind of incarceration, so that may or may not have a bearing on your thought process on that, so.
Yes, sir.
We'll pick that up when we're back.
Thank you.
all right.
Thank you, Your Honor.
State of Ohio recalls Shannon Brunson, case number CRB 26468.
This is State of Ohio versus Shannon Brunson, CRB 26468. Ms. Brunson had entered a plea to the theft charge earlier, and we had her screened. And it looks like we have a positive screen for amphetamine, benzodiazepines, and methadone.
Yes, sir, they're all prescribed.
Okay, do you have any proof of those prescriptions today?
I can get proof. I don't have it with me, but I can get proof from all of them.
All right, here's what I'm going to do.
I mean, I can call my counselor right now at the clinic, and he would.
What I'm going to do is I'm going to set
I'm sorry, I've never done this. I didn't know this.
That's okay. I'm going to set you a bond for 2,500 OR, and I'm going to set you back for August the 7th as a sentencing hearing at that time. And you will need to bring proof of your prescriptions and your counseling to that hearing.
Okay.
Okay? So we'll see you back August 7th at 10 a.m. And you're going to need to go to the Lawrence County, well, she's got a bond up with salary, so I'm assuming she doesn't. Okay. So you'll be back here August 7th at 10 a.m.
Here?
Yep. Okay. Bring proof of your prescription and your counseling.
Okay.
Okay? And then we'll wrap the matter up at that time.
Okay.
All right. Thank you.
State of Ohio versus Benjamin Shepherd, case number TRC 213595.
All right, this is State of Ohio versus Benjamin Shepherd, TRC 213595. It's set as a sentencing hearing today. Looks like this was on reviews. Looks like he's working on paying these off. You have any payment today, or is there any community service?
Yes, sir, I do have $60.
Okay. All right, I'll give you some more time. Set you back for September 25th, and that'll be a sentencing hearing.
Okay.
All right, thank you.
Thank you.
Yeah, we're gonna need to see the clerk to pay your $60.
State of Ohio versus Cody Mead, case number TRC 253047, ABC and D, PRD 251553, PRD 251873, A and B, PRD 222101, A and B, PRC 221690, A and B, PRC 23152, A, B, and C.
All right, I'm gonna hope that is sufficient caption for the case. Cody Mead.
Judge, I'm familiar with Cody. In fact, some of those are probably my review hearings. It's on today for sentencing on a case that Mr. Steyer represents him on. I know Cody. I've not seen him. It's been a minute since I've been in the hallway, or lobby. I don't know why he's not here.
All right.
It's on for sentencing.
Now, notice failure to appear, there will be a bench warrant to issue in 7 days.
I'll advise Mr. Steyer. Thank you, Judge.
All right, thank you, Mr. Smith.
State of Ohio recalls Bertha Remy, case number CRB 26233, A and B. She's back in holding. Bertha Remy.
All right, this is State of Ohio versus Bertha Remy, CRB 26-233 A and B. All right, we had this matter recalled. Ms. Remy wanted some time to think about whether she wanted to go to jail or go back or go to inpatient treatment. And so I gave Ms. Remy some opportunity to consider that while she was held in the back. Ms. Remy, what do you want to do? I would tend to agree 100% with you. I thought that was much easier of a decision than you did. And so I wanted to give you an opportunity to sit back there and think about it.
Well, honestly, the only reason I had to debate was because the treatment plan is longer than the adjustment.
Do you understand that?
So that being the only reason of my debate.
I gave you the option. I wasn't going to criticize you if you came out and said jail. That would be your choice. But I agree with you. I agree with that. But there's times that people get free will in this court, and there's times that they don't. I was giving you free will, and I'm glad you came to what I believe is your best decision. But if you had chose otherwise, then I would oblige.
If I can't handle it, then there's always been
That's 100% accurate.
decisions first.
I agree. So I will then order you into inpatient treatment at Bethesda. And I'm going to keep your current bond in place, but I'm going to note that you're to go inpatient with Bethesda. Can you guys take her
Today?
now?
Yes.
Okay, so she can be released here today. That way you don't have to go to the jail and pick you up at the jail. You can be released today straight to Bethesda here today for pre-inpatient treatment. Okay? All right, I'm going to set you back September the 4th. And that's going to be for a review at 9 a.m.
So Your Honor, she'll be held here in the jail, that have to get transport to come get her. So she'll be held here in jail, and then
They'll be like 5 minutes.
we'll release her from there, just to let her know how things are going to go.
Yeah, you're not going to jail, they're just going to hold you till
Transport.
transport arrives, and then they'll take you straight from there. Okay?
Okay.
All right. Thank you, Ms. Raymond.
Thank you.
Best of luck.
We're finished, Your Honor.
All right. Sir, do you have a case? Oh, okay. All right, court is adjourned.